Hi, I'm Janice Switlo, and today I'm recording part 24 of my book, Cede 2.0, regarding the First Nation Land Management Act. Then Minister of Aboriginal Affairs and Northern Development, Bernard Valcourt, recently, quote, faced questions from MPs, members of Parliament, Wednesday evening during Committee of the Whole in the House of Commons, which focused on his department. Many of the questions centered on education, child welfare, and youth suicide rates. At one point, a frustrated Valcourt, facing a question from an NDP MP about suicidal rates, blurted that the fate of First Nations children was not the responsibility of the Federal Aboriginal Affairs Department. Quote within quote, given the horrific death rates that we have among children who do not have access to schools, if you can tell us what the national suicide rate is on reserve among young people under his watch, said NDP MP Charlie Angus, whose Simpson James Bay riding includes the communities, a number of communities. The assertion of the honourable member that these children are under the minister's watch shows a great misunderstanding by the members of the responsibility of the Department of Indian Affairs and Northern Development, said Valcourt. These children are first and foremost the responsibility of their parents throughout Canada. When the member talks about an obligation, I will remind the honourable member that this is a policy matter. This is a policy decision to reimburse provinces and to fund the agencies, said Valcourt. Valcourt, unsure about details when questioned by MPs on First Nations Children, Youth, APTN National News, May 14, 2015. Annual parliamentary appropriations, not constitutional legal obligation. This is what Valcourt is saying. On May 14, 2015, Cheryl Maloney, then president of the Nova Scotia Native Women's Association, reported that, quote, Minister Valcourt has sent notice to Mi'kmaq chiefs that children will be removed from social budgets in April 2016. We have been put on notice. While another reported, the Maliseet chiefs got the same letter. End of quote. This is what is underway through the Section 35 Constitution Act 1982 doctrine, through UN DRIP, and through opt-ins like the FNLMA. Only the net result, once all are so captured, will not be a minor amendment to the treaties. It will be the end of the treaties, the end of obligations. Only policy matters will remain. Quote, the Supreme Court of Canada has recently granted Aboriginal First Nations expanded powers over their ancestral hunting, fishing, and gathering grounds. At the same time, however, the Canadian federal government has severely scaled back the environmental review of major energy projects. Provinces can, according to the High Court ruling, exercise power to override Native groups' opposition when vital interests are deemed at stake. Joel Connolly, Native Band in Canada, rejects $1.15 billion inducement from gas pipeline builder. SeattlePie.com, May 13, 2015. There is no way out of the FNLMA regime under the FNLMA provisions. Once the land code and individual agreement are agreed to by the band members, you will be, quote, reborn, end of quote, a new legal entity for purposes of the FNLMA, and only for domestic purposes, not for general international business. Even if there were flaws in the ratification process, those flaws can be deemed unimportant. The only real issue after the fact is whether consent was fully informed and freely provided. Further proof that the FNLMA regime is a surrender of the full reserves is in the need for surveys. No surrender can proceed without a survey being done. This has often slowed down proposed developments, surveying out the portions of the reserve to be surrendered for purposes of leasing, which is handled by the Surveyor General of Canada. To get around this, an amendment to the FNLMA was needed. Chief Robert Louis explains, quote, Chief Robert Louis, Chair, Lands Advisory Board. Since January 1, 2000, when 3 Framework Agreement First Nations implemented their land codes to begin the new millennium, 2 issues have restricted the efficient implementation of the Framework Agreement. Our first concern has been the problem of how to describe reserve lands, which unfortunately have uncertain boundaries. Clauses 627 to 631 in Bill C-38 will provide the solution. Yes, that Bill C-38, more than 400 pages. Bill C-38, an act to implement certain provisions of the budget tabled in Parliament on March 29, 2012, and other measures received royal assent on June 29, 2012. Now the Jobs, Growth and Long-Term Prosperity Act, Statutes of Canada 2012, Chapter 19, which also substantially changed federal environmental law, environmental assessment law, fisheries law, operations of the National Energy Board, and Income Tax Act charity provisions affecting environmental organizations. Meaning those in the FNLMA regime wanting that survey amendment and another amendment that lessened the requirements regarding environmental protection law under FNLMA had to support Bill C-38. Currently, a First Nation and the minister cannot exclude land from a community's land code when the land's reserve status is uncertain. The Framework Agreement and the First Nations Land Management Act only contemplate excluding a, quote, portion of a reserve, end quote. As a result of this uncertainty, many community votes have been delayed, some for years, until boundary issues are resolved. In order to avoid similar delays in the future, the proposed amendments are to change the Framework Agreement and the First Nations Land Management Act to enable a First Nation and the minister to exclude land from a community land code when it is uncertain whether or not the parcel of land forms part of the reserve. In addition, the proposed amendment provides that a legal description will be any description the Surveyor General of Canada considers sufficient to describe the land. What is being referred to here is really a First Nation being able to vote once it goes through its process and the community wants to vote and get a land code in place. Currently, our problem is fettered. This is Robert Louis speaking. There is no process if you have uncertain boundaries. If you have erosion or accretion on the outskirts of a boundary, for example, where exactly is that boundary? The way it is worded now, the Surveyor General of Canada has to have an accurate description. In these proposed amendments, we are saying that the Surveyor General can put in another method to accurately describe it without having the exact boundaries. That boundary will be an issue that will be and can be resolved at a later date. That is what we are trying to do. Right now, we have had First Nations excluded from going to a vote and having that process so that they can complete it and get on with the business. Mr. Aronson, if I could add to that, part of the objective of this particular amendment is that there have been disputes between the Surveyor General of Canada and First Nations over, for example, a specific boundary of the reserve. This amendment says that on an interim basis, in order to allow the First Nations to move ahead with the land code, we can put a dotted line instead of a straight bold line as the boundary in dispute. This dispute can continue, for example, if it is a specific claim, it can go either to the specific claims tribunal or it can be dealt with through a specific claim. Similarly, in the individual transfer agreement, it may be a question of taking a long time to get all the survey work done. Sometimes it can take several years to get all of the survey work done, depending on the location. On an interim basis, this will be the boundary, and when the survey work is completed, then the boundary will be finalized and the First Nation will be able to assume its authority over the full area of land. The purpose of this is to use as appropriate, whereas currently the Surveyor General is bound by the Canada Lands Survey Act, which requires specific criteria in order for a survey to be approved. Now the Surveyor General is not bound by those criteria. A good illustration is that many reserves are centuries old, and the boundaries, when they were originally established, were established from a rock over by a lake to a tree 50 chains away. That tree may no longer be there, so there may be some dispute because a third party has had land grants issued to them that may overlap that boundary. This can take some considerable amount of time to resolve. On an interim basis, the parties can agree, without prejudice to a final boundary, that the First Nation can assume authority under its land code and approve a land code with an interim legal description. Essentially, this allows things to move ahead more quickly, and if the boundary cannot be resolved over the long term, the parties are still free to litigate or do as they would do in other situations where there is a boundary dispute. Proceedings of the Standing Senate Committee on National Finance, Issue 22, Evidence, June 13, 2012, afternoon meeting. It is trite. If the FNLMA regime was not a surrender process, there would have been no survey issue to contend with. Subsequent to Appleseed, my first discord on this subject, a new section was added to the Framework Agreement. Section 13.1, title to First Nation land is not changed when a First Nations land code takes effect. And reflected in Section 5 of the FNLMA, title to First Nation land. For greater certainty, except for First Nation land exchanged in accordance with Section 27, A, title to First Nation land is not affected by the Framework Agreement or this Act. B, First Nation land continues to be set apart for the use and benefit of the First Nation for which it was set apart. And C, First Nation land continues to be land reserved for the Indians within the meaning of Class 24 of Section 91 of the Constitution Act 1867. Recall the issue raised in Appleseed was whether the individual agreement intended to effect a transfer of administration and control to Her Majesty in right of a province. Note that both those sections deal with the defined term, First Nations land, defined in those very instruments, which reads as follows. Quote, First Nation land means reserve land to which a land code applies and includes all the interests or rights in and resources of the land that are within the legislative authority of Parliament. First Nation land in respect of a First Nation means all or part of a reserve that the First Nation describes in its land code. The first definition was from the FNLMA, the Act. The second definition was from the Framework Agreement. Saying that title to something being created and defined by the very instruments is not affected by those instruments is lunacy.